Welcome back to Wickedly Judged, the podcast where we expose the flaws, failures, and outright corruption in the U.S. justice system. If you've been with us for a while, you know that wrongful convictions are not rare mistakes. They are predictable outcomes of a broken system, and today's case is no exception. Before we dive in, I want to let you know about the 2 episodes before this that includes an exclusive interview with Lisa Arrowood, the mother of Garrett Arrowood and the sister of the victim. Lisa's perspective is powerful, and her story offers a deeply personal look at how wrongful convictions tear families apart. Make sure to go back and listen to those episodes if you haven't already. And while you're at it, go back and listen to the first 3 episodes of Johnny Watkins' case. More examples of prosecutorial misconduct and corruption. The story you're about to hear is one of systemic failure, prosecutorial misconduct, and a justice system that prioritizes convictions over truth. It's about a man named Garrett Arrowood who sits in prison for a crime he didn't commit. His case is riddled with deception, corruption, and injustice. And yet, every single one of his post-conviction motions has been denied. Why? Because in the U.S., when you file an appeal, you have to go back to the same court that convicted you, the same judge, the same prosecutor. That's like asking a dirty cop to investigate their own misconduct. Today, we're going to break down Garrett's case, discuss the systemic issues it highlights, and explore what needs to change. We'll also take a closer look at the major contributors to wrongful convictions, Brady violations, junk science, corruption, and the uphill battle of post-conviction motions. But before we dive in, I want to remind you to subscribe to Wickedly Judged wherever you listen to podcasts. And if you find value in what we're doing, consider sharing this episode. The more people know about cases like Garrett, the harder it is for the system to ignore them. Now, grab your coffee, settle in, and let's get into it. Let's start with the prosecution's case, because, let's be honest, it fell apart before the trial even began. The original forensic evidence suggested a specific time of death. The coroner, under oath, testified that the time of death was 12 to 24 hours prior to the body being found. This time frame didn't match Garrett's whereabouts. GPS places him miles away from the crime scene, and a timestamp and date stamp security photo from a pawn shop corroborates his alibi. But the prosecutor wasn't satisfied with the coroner's findings. They pressured the coroner to say that, under the right conditions, it was possible that the time of death could be as much as 36 hours prior to the body being found. And the prosecutor ran with it. They didn't present it as a possibility, they presented it as fact. They told the jury that the time of death was 36 hours prior to the body being found, which conveniently placed Garrett outside of his alibi window. This wasn't just a small tweak to the evidence. It was a complete distortion of the facts. The prosecution knew that the original time frame didn't implicate Garrett, so they manipulated the science to fit their narrative. This kind of behavior isn't just unethical, it's a direct attack on the integrity of the justice system. This manipulation of forensic evidence is disturbingly common. According to the Innocence Project, over 40% of wrongful convictions involve misapplication of forensic science. Prosecutors don't always have the evidence they need to convict, so instead of following the facts, they force the facts to fit their case. But the manipulation didn't stop there. The prosecution also relied heavily on the testimony of a jailhouse informant, a man with a long history of lying to secure reduced sentences for himself. Jailhouse informants are responsible for nearly 20% of all wrongful convictions that are later overturned by DNA evidence. These informants are often incentivized to fabricate stories, yet their testimonies are frequently used to convict innocent people. Imagine being Garrett. You know you're innocent. You know the evidence doesn't support the charges against you, but suddenly you're being accused by someone who has everything to gain by lying about you. And the jury, they believe him. Let's talk about the jury. Well, actually, we'll get to that in a bit. But let's just say the odds were stacked against Garrett long before the trial even began. Now let's talk about Brady violations. These are one of the most common forms of prosecutorial misconduct, but they're also one of the least punished. A Brady violation happens when prosecutors withhold evidence that could exonerate a defendant. The term comes from the landmark 1963 Supreme Court case, Brady v. Maryland. In that case, the court ruled that prosecutors must turn over exculpatory evidence, which is evidence that could prove a defendant's innocence. But here's the problem. The enforcement of this rule is practically non-existent. In fact, a study by the National Registry of Exonerations found that prosecutorial misconduct was a contributing factor in 30% of all known wrongful convictions. That's nearly 1 in 3 cases. One infamous example is the case of John Thompson. John was convicted of murder and spent 14 years on death row before being exonerated. It was later revealed that prosecutors had withheld a lab report proving his innocence. When John sued for damages, the Supreme Court ruled 5-4 against him, stating that the district attorney's office could not be held liable for a single Brady violation. And then there's the case of Michael Morton, who spent 25 years in prison for the murder of his wife. Prosecutors withheld evidence that pointed to another suspect, including a bloody bandana and witness statement. When the truth finally came out, Michael was exonerated, but the prosecutor, Ken Anderson, only served 10 days in jail for his misconduct. 10 days. Brady violations aren't just oversights. They're deliberate acts of misconduct, and the lack of accountability means they will continue to happen. Now, let's talk about another major contributor to wrongful convictions, junk science. Junk science refers to forensic methods that lack scientific validity but are presented in court as reliable evidence. The problem is so widespread that in 2009, the National Academy of Sciences released a damning report stating that many forensic disciplines lack a solid scientific foundation. Some examples of junk science are bite mark analysis. Bite mark evidence has been discredited, yet it's still used in court. Studies show that even trained forensic odontologists frequently disagree on whether a bite mark matches a suspect. Here's an example. Keith Harward spent 33 years in prison based on bite mark evidence. DNA testing eventually proved his innocence. Hair comparison. The FBI admitted in 2015 that its analyst overstated the reliability of hair matches in 95% of cases reviewed. 95%. Arson investigation. Outdated techniques rely on myths, such as the belief that certain burn patterns indicate intentional fires. An example is Cameron Todd Willingham, who was executed in Texas in 2004 for allegedly setting a fire that killed his children. Modern fire science later determined the fire was likely an accident. The problem with junk science is that it carries an air of authority. Jurors trust forensic evidence because it sounds scientific. But when that science is flawed, the results can be catastrophic. Let's circle back around to Garrett's case and talk about the jury. In capital cases, a 12-person jury is the standard. It's what the Constitution intended. A larger jury ensures a fairer, more diverse group of jurors, which makes wrongful convictions less likely. But in Garrett's case, the prosecution cut a backroom deal to reduce the jury to just 6 people. And here's the twist. The public defender signed off on this shady deal. Why? To take the death penalty off the table. But here's the thing. The death penalty was never on the table to begin with. This was a manipulation tactic, plain and simple. And here's where the corruption goes even deeper. The state attorney general, whose office was responsible for Garrett's conviction, was later charged with 11 counts of fraud and extortion. These charges included conspiracy, wire fraud, and tax fraud. He faced a maximum sentence of 129 years. But instead of facing real accountability, he struck a plea deal. He pled guilty to just 4 counts and was sentenced to a little over 3 years in prison. But how much time did he actually serve? 11 months. Meanwhile, Garrett is still in prison, serving life without parole for a crime he didn't commit. Nobody has reviewed his cases. Nobody is holding this state attorney general's office accountable. Garrett has filed multiple post-conviction motions, and every single one has been denied. Post-conviction motions are reviewed by the same courts that issued the original conviction. Judges are often reluctant to admit they made a mistake. Overturning a conviction means acknowledging that the system failed, and that's something the courts are hesitant to do. So let's break it down of why post-conviction motions fail. Procedural barriers. One of the most significant reasons post-conviction motions fail is due to procedural technicalities. Courts often prioritize the procedural aspects of a case over the substantive claims of innocence. And here's how. Missed deadlines. Many states impose strict deadlines for filing post-conviction motions. For example, in some jurisdictions, defendants have only 1 year after their conviction becomes final to file a motion. If that deadline is missed, even compelling evidence of innocence may not be heard. Example, in the case of Daniel Villegas from Texas, his initial appeals were denied because they were filed after the statute of limitations had expired, even though key evidence of coercion in his confession existed. Procedural default rules. If a claim wasn't raised during the initial trial or direct appeal, courts often refuse to consider it in post-conviction proceedings. This is known as procedural default. Essentially, if the defense attorney didn't bring up an issue earlier, it's often deemed waived and cannot be revisited. Why this matters. Many defendants rely on incompetent or overburdened public defenders during their trials, and critical issues may be overlooked. However, the system penalizes the defendant for their lawyer's mistakes. Reluctance to overturn convictions. Judges are often reluctant to overturn convictions because it reflects poorly on the justice system as a whole. Admitting that the system failed can be seen as undermining public confidence in the courts. This reluctance manifests in several ways. Presumption of finality. Courts operate under the principle that convictions should be final. Once a verdict is reached, there's a strong bias against reopening the case. Judges often justify this by claiming that reopening cases would flood the courts with frivolous claims, even though this argument is not supported by data. Judicial ego and career incentives. Judges who preside over the original trial may feel personally invested in the outcome. Admitting an error could damage their reputation or career. Similarly, appellate judges are often hesitant to criticize their peers on lower courts. Prosecutorial opposition. Prosecutors frequently opposed post-conviction motions, even in cases where new evidence of innocence arises. This opposition stems from a desire to protect their conviction record, as overturning a case can be seen as a professional failure. Here's an example. In Anthony Ray Hinton's case, prosecutors fought against his release for nearly 3 decades, despite overwhelming evidence that the bullet used in the crime did not match his gun. Lack of access to evidence. Defendants seeking post-conviction relief often face significant challenges in assessing the evidence needed to prove their innocence. This includes destroyed or lost evidence. In many cases, evidence is destroyed or lost after the trial, especially in older cases. Some jurisdictions have policies that allow evidence to be discarded after a certain period, even if the defendant is still incarcerated. An example, in Cameron Todd Willingham's case, critical arson evidence was destroyed, making it impossible to re-evaluate the flawed forensic techniques used in his trial. Prosecutorial withholding of evidence. Prosecutors may fail to disclose exculpatory evidence, even during post-conviction proceedings. While this is illegal, it often goes undiscovered because defendants lack the resources to investigate. In John Thompson's case, prosecutors withheld a lab report that proved his innocence for 14 years. Denial of DNA testing. Even in cases where DNA evidence could prove innocence, courts sometimes deny requests for testing. This is often justified by claiming that the defendant's conviction was based on other evidence, rendering the DNA irrelevant. In Troy Davis's case, despite significant doubts about his guilt, courts denied requests for further testing and evidence review. Inadequate legal representation. Post-conviction proceedings often rely on the quality of legal representation, and unfortunately, many defendants do not have access to competent attorneys during this stage. Here's why. No right to counsel. Unlike at trial, defendants are not guaranteed the right to an attorney during post-conviction proceedings. Many are forced to represent themselves, navigating complex legal procedures without the necessary expertise. Underfunded public defense. Even when defendants have access to legal aid, post-conviction attorneys are often underfunded and overworked. This leads to poorly prepared motions and missed opportunities to present compelling evidence. Lack of resources for investigation. Post-conviction attorneys rarely have the budget to hire investigators, forensic experts, or other specialists needed to uncover new evidence. This puts indigent defendants at a severe disadvantage. High burden of proof. Proving innocence in post-conviction proceedings is often far more difficult than during the original trial. Defendants must meet a higher standard of proof, which can be nearly impossible to achieve. Here's how. Clear and convincing evidence. Many states require defendants to present clear and convincing evidence of their innocence, a standard far more stringent than the beyond a reasonable doubt standard used in trials. This creates an unfair imbalance, as the system essentially demands more proof post-conviction than it did to convict in the first place. Harmless error doctrine. Even if errors are identified during the trial, courts often dismiss them as harmless. This doctrine asserts that the errors wouldn't have changed the outcome of the case, even if they were significant. Skepticism towards recantations. Witnesses who recant their testimony are often dismissed as unreliable, even when their original testimony was coerced or fabricated. Courts tend to view recantations with extreme skepticism, making it difficult for defendants to use this as a basis for relief. Systemic bias against the poor and marginalized. Finally, systemic bias plays a significant role in the failure of post-conviction motions. Defendants from marginalized communities face additional hurdles, including racial bias. Studies have shown that Black and Hispanic defendants are less likely to have their post-conviction motions granted compared to white defendants. Implicit bias within the justice system continues to disadvantage defendants of color. Economic disparities. Wealthier defendants can afford private attorneys, forensic experts, and investigators, giving them a significant advantage in post-conviction proceedings. Indigent defendants, on the other hand, must rely on underfunded public defenders or represent themselves. Political pressures. Elected judges and prosecutors may feel pressured to appear tough on crime, leading them to oppose post-conviction relief, even in cases with compelling evidence of innocence. Post-conviction motions fail not because the evidence of innocence is lacking, but because the system is designed to prioritize finality over fairness. Procedural barriers, judicial reluctance, lack of access to evidence, inadequate legal representation, high burdens of proof, and systemic bias all contribute to the uphill battle that defendants face. Reforming these processes is essential to assuring that justice is truly served. Now that you've heard Garrett Arrowood's story, you might be wondering, what can you do to help? The truth is, wrongful convictions are not just a problem for those directly affected. They're a failure of the entire justice system, and we all have a role to play in fixing it. Here's how you can take action today. Share Garrett's story. Sharing is one of the most powerful tools we have. Post this episode on your social media accounts. Send it to your friends and family and talk about it in your communities. Use the hashtag #JusticeForGarrett or #JusticeForJohnny to spread awareness about these cases and the broader issue of wrongful convictions. If you're on Spotify, Apple Podcast, or iHeart, don't forget to hit follow and leave a review. Reviews help us reach more people who care about justice reform. Advocate for justice reform. Reach out to your local representatives and demand reforms in areas like forensic science, prosecutorial accountability, and independent conviction reviews. Even a simple email or phone call can make a difference. Support organizations like the Innocence Project, Equal Justice Initiative, and other advocacy groups working to free the wrongfully convicted and reform the system. Join our community. Stay connected with Wickedly Judged by subscribing to our email list. We'll send you updates on Garrett's case, future episodes, and ways you can get involved. Head to our social media pages and follow us for daily posts about justice reform, behind-the-scenes content, and updates on our upcoming video and live streaming formats. Together, we can build a community of advocates who refuse to stay silent. This is not just a podcast. This is a movement. Donate to the cause. If you're able, consider donating to advocacy organizations or directly to Garrett's Legal Defense Fund. Every dollar helps fight for justice and supports the families of the wrongfully convicted. Partner with us. If you're part of a legal organization, advocacy group, or media outlet, we'd love to collaborate with you. Let's amplify these stories and work together to make a difference. Reach out to us via email, wickedlyjudged@gmail.com, social media, or call us at 513-393-7452 to start the conversation. Be part of the change. Take a moment to reflect on how you can contribute to justice reform in your own way, whether it's attending a town hall, volunteering with an advocacy group, or simply staying informed. Every action counts. Stay tuned for more. Make sure to subscribe so you don't miss any episodes. Engage with us. We want to hear from you. If you have thoughts on this episode, cases you think we should cover, questions about Garrett or Johnny's case, send us an email or message us on social media. Your voice matters, and we're here to listen. Remember, change starts with awareness, but it doesn't end there. By taking even one of these actions, you're helping to create a justice system that prioritizes truth over convictions and fairness over finality. Together we can make a difference, not just for Garrett, but for the countless others trapped in the same broken system. Thank you for being part of this fight. Let's keep pushing for justice. As we wrap up today's episode, I want to leave you with a few final thoughts. Garrett Arrowood's story is not just a singular tragedy. It's a reflection of a justice system that too often prioritizes convictions over truth, finality over fairness, and power over accountability. And while Garrett's case may seem like one of many, his life and the lives of countless others in his position deserves our attention, our outrage, and our action. We've talked about the systemic failures that led to Garrett's wrongful conviction, the manipulation of evidence, the misuse of junk science, the reliance on incentivized testimony, and the procedural barriers that make post-conviction relief nearly impossible. But the truth is, these failures are not isolated incidents. They are symptoms of a broken system, a system that we, as a society, have the power to change. I started Wickedly Judged because I believe in the power of stories to spark change. And I know that change doesn't happen overnight. It takes persistence, passion, and people like you, the listeners, who care deeply about justice and fairness. Every time you share an episode, every time you talk about these issues with someone in your life, you're helping to build the momentum we need to create a better system. And that's not all. Our merchandise line for Wickedly Judged is launching soon. This isn't just about creating cool products. It's about building a community of advocates who wear their passion for justice proudly. Whether it's a hoodie, a mug, or a bracelet, every purchase will help support our mission and spread awareness about wrongful convictions and justice reform. If you want to stay updated on Garrett's case or Johnny's case, our new merchandise drops, make sure to subscribe to our email list. It's the best way to stay connected and get exclusive content, behind-the-scenes updates, and opportunities to take action. Before we go, I want to remind you, change starts with awareness, but it doesn't end there. Take the next step. Share this episode. Talk about Garrett's story. Talk about Johnny's story. Support organizations like the Innocence Project, the Equal Justice Initiative, or local advocacy groups in your area. Reach out to your representatives and demand accountability in our justice system. And if you have the means, consider donating. Garrett Arrowood's story is a heartbreaking reminder of what happens when the system fails. But it's also a call to action, a chance to stand up and say, this is not acceptable. Together, we can do better. We must do better. Because justice isn't just about punishment. It's about truth, fairness, and humanity. Thank you for listening to Wickedly Judged. Thank you for caring about these stories and for being a part of this fight. Until next time, stay informed, stay outraged, and never stop seeking the truth. And remember, every voice matters, including yours. Let's keep fighting for Garrett and Johnny and all the others like them, and for a justice system that's worthy of its name, because no one deserves to be wickedly judged.